Hello viewers, I'm Ron Grant coming to you live and direct from Tortola in the Virgin Islands. Thank you so much for joining me for this special report. This evening I am joined by the Director of Public Prosecutions in the Virgin Islands, Miss Tiffany R. Scatliffe, who is going to be discussing, of course, a number of things, including the office, its role, and of course many questions that we have regarding the DPP. We are so delighted to have the DPP in for this exclusive. We'll be right back after a word from our sponsors. You're watching 284 Media.
Yo, everything good there?
Aye. This thing got me one way, daddy.
What do you mean?
Ever since I hook up with this thing, can't eat, I can't sleep. This is the first thing I touch it when I reach home.
What do you really? Hey, this thing like you know.
Dad, this thing got me staying home. Keeping out that trouble me.
Wow. What your name is?
Shit. I talking about my CCT life.
Don't worry about missing your favorite series, sports, news, and local programming. Come to CCT today and sign up for CCT Live to access over 80 channels. CCT Live. Bring it home.
1 month free trial turn into 5. 5 months turn into, well, you know I hustle. I watching ball. I been watching football. Dad, Nickelodeon, Paw Patrol. I am hooked. Hook, I tell you.
Viewers, welcome back and thank you so much for sticking with us. As promised, I am joined by the Director of Public Prosecutions in the Virgin Islands, Miss Tiffany R. Scatliffe, DPP. Thank you so much for your time. Good evening and welcome to 284 Media.
Good evening, Mr. Grant. Thank you for having me.
I am so delighted to discuss, of course, today a number of things concerning the DPP's office. I'd like you to begin by telling us when exactly was the DPP's office established?
The DPP's office was established on June 15, 2007, when the 2007 constitutional order came into force. We are formed under Section 59 of the Constitution order that creates the post of the Director of Public Prosecutions and, by extension, the office.
What exactly came about in the creation of the office of the DPP?
Well, came about the creation. There was a need for an independent prosecutorial service in the Virgin Islands. Previously, it was under the remit of the Attorney General.
Okay.
And what became the DPP's office was the Criminal Division. And the unfortunate thing is many people do not understand the role and the purpose of a prosecution office. Even though we've been in existence for 15 years, we celebrate our 15th anniversary on June 15th of this year. Still many people within the government service and the public at large do not have a clear understanding of what the prosecution office does. We have 3 main focuses. 1, we institute, take over, or discontinue criminal proceedings. The other thing we do is to make sure that there is justice for everyone in the criminal justice service. And of course, we're there to serve as independent advisor to the government on all criminal matters. Those are our main duties.
Understood. Now, how many DPPs have we had since the new dispensation, and are you the first local to hold this post?
I am the first local to hold the post. We have had, I am DPP number 5.
Okay.
We've had Mr. Terrence Williams, who was our first DPP, who was actually DPP prior to the commencement of the office. I believe he received his in 2006. Then we had Miss Elizabeth Hines, who was DPP from 2010 to 2012, and then Mr. Wayne Rajbansi was the DPP from 2012 to 2016, and then Miss Kim Hollis, Learned Queen's Counsel, was DPP from 2016 to 2019.
Understood. I'd like to discuss the independence of the office. To whom does the DPP report to?
Technically, the DPP does not, when it comes to our constitutional mandate, which is the prosecution of offenses, we do not answer to any other authority of power. Administratively, the DPP reports directly to His Excellency, the Governor, the same as with the Commissioner of Police. That is because when you're dealing with the criminal justice system, especially bearing in mind that this is the aspect of justice that where someone's freedom can be taken away as punishment, you have to make sure that any decision made is free from any form of external or personal bias.
With that in mind, I thank you for clarifying that. Can the office of the DPP be influenced from or by any external source, whether to prosecute a particular case or not?
No, no one can influence or otherwise, to use your term, or otherwise influence the office to prosecute anyone or to discontinue anything. And the same goes for the police as well. Police and prosecution do go hand in hand. It's the same independence that applies to both of those establishments. Because when it comes to investigating a crime, one must look at it impartially. You have to have an open mind in reviewing it to make sure all the elements of the purported offense have been met, and most importantly, you do have the correct offender.
Wonderful. Now, I want to talk about these steps. What are these steps that are considered by your office in essentially advising the police to lay charges or decide to take a matter to court? What type of deliberations are done before deciding such?
Well, in order to establish the deliberations and the steps, we need to explain the full progress of a criminal prosecution from investigation to when it goes to court. Someone goes to the police, they make a complaint. Then that complaint is investigated by the police. That means they gather statements, they get evidence, they take photographs, whatever that entails, investigation. And then the file is submitted to the DPP's office, and we will review the file. There is a two-pronged test that we use in establishing whether or not to commence criminal proceedings. Now, this test was created by the Crown Prosecution Service in the United Kingdom and is used by most DPP's office within the Commonwealth. That test is, the first one, is there sufficient evidence? It's not the same as when people hear on television, beyond a reasonable doubt. We haven't gotten to that stage yet. That's when we go to court. But in order to instigate those prosecutions, we have to make sure that there is sufficient evidence that would more than likely lead to a conviction. Once that's been established, then we have to look into whether it's in the public interest to commence that. So once we do that, then it's referred back to the police, and then a complaint is drafted, and then that complaint is laid before the magistrate's court. Sometimes the police may have to do additional work for the investigation to make sure that it does meet that evidential burden. And sometimes we will give opinions to the police, and not just the police, we also deal with files from the Department of Immigration, Her Majesty's Customs, the Financial Investigations Agency. Those are the main investigative agencies within the territory. And we deal with all of their files and making sure that there is sufficient evidence and it is in the public interest to proceed.
Now, in your experience, DPP, with this in mind, have you ever dropped or not prosecuted a matter because you thought that the matter would be unsuccessful in the prosecution?
The only time a matter is discontinued is if once, well, first of all, a matter is not prosecuted if it fails either one of those two tests. And sometimes there are a lot of different factors. You can't just say that it just meets this specific criteria.
Okay.
You have to look into different things. Also, when it comes to court, if we find out, for example, let's say the person has an alibi or they have a defense in law, then that will make us have cause to review the matter and then determine whether or not we will cease or discontinue the matter. And while we're on that, I would like to also raise, especially in certain matters, we've gotten the response in recent times where persons feel it's appropriate to make a complaint to the police and then about a week or two later sending in a letter to my office saying, we don't want to proceed anymore. That's not acceptable because significant resources are entered into by the police and the DPP's office in making sure that your matter gets to court. Those resources and that energy could be used for another matter. There is a procedure. If you feel you do not wish to continue, you have to take your matter to the police. Everyone has an investigative officer or a case officer. That person is responsible for your investigation. If you feel you do not wish to proceed, you have to give what is called a witness statement. The police refer to it as an MG11. And you have to state in that why you want to stop the prosecution. Were you forced? Did anyone entice you? Were you promised anything? And then they will submit that to the DPP's office and then we'll review it. Because not every matter, just because a complainant does not wish to proceed, does not mean it will be automatically stopped. We do have the public interest to serve. So for example, matters of domestic violence, serious violence, matters involving children, We normally, or even public offenses, meaning that breach of trust, theft of public funds, those type of matters, we would normally say, no, we're going to proceed. Most people seem to have these perceptions that if something arises, you can just simply discontinue. Another thing that we've noticed is that persons, especially in theft cases, like to say, oh, I paid back the money, and no, we don't want to go ahead. No, it does not matter. Just because you paid back monies in the theft does not mean that the offense no longer exists. Because at the time you took it, you did intend to permanently deprive the
Correct.
victim of those monies. So we try to make sure that everyone understands that, especially with domestic violence, because what most people do not understand, domestic violence is what you call an escalating offense. It starts with a shove, then it goes to a chokehold, then it goes to a broken limb, then it goes to a wounding or a grievous bodily harm, up until attempted murder or even murder. We have a responsibility to make sure that victims, especially in domestic violence matters, are safe.
Thank you so much for bringing that up, because I did have that to note, especially in matters of domestic violence, abuse or assault involving a relationship, whether it be a boyfriend, a girlfriend, or husband and wife. We do see that over time with persons with late charges, time has passed, and there's a change in feelings. And I was curious as to what your process was in that regard. So thank you so much for bringing that to the forefront. I have to ask you though, I have observed from many recent news reports that settlements have been awarded by the courts to individuals for malicious prosecutions. I believe that's the term. Can you share what ingredients must be met in order to bring a successful claim for malicious prosecution? What must be proven to be successful in order to for this to happen?
Well, the case of malicious prosecution, contrary to, despite the name, is not a matter for my office. It's a matter for Madam Attorney General.
Okay.
And that would be a question better answered by her.
Understood. When we go to some matters of bail application, can you explain the process for bail applications?
Okay. Bail does not mean that someone is let go after being charged for an offense and brought before the court. Bail is to secure the person and make sure that they appear. When someone appears before the court in their first instance, the magistrate's court, their counsel will normally make an application for bail. Based on certain conditions, sometimes the Crown will object to bail. For example, if they're a flight risk, the nature of the offense, whether they can be a threat to intimidate witnesses or hinder the investigation and prosecution. Those are just a matter of things that we would bring up. But normally, bail is to make sure that that person returns to court. We normally do not object to bail unless it is murder or very serious offenses. Or in the case of, let's say you have a child involved as a victim, and that person may be friends with the family or have access to that child, we would also ask for bail to be withheld. Now, the DPP's office does not make the decision for bail. That is left to the court, whether it's the magistrate's court or the high court. When most people go to magistrate's court, and let's say the magistrate in her own discretion decides that bail should not be awarded, then persons can go to the high court to consider saying. In the case with murder, the magistrate cannot consider bail for that offense. That is something that the high court has to decide. And the high court judge who would determine the matter would think into cases the length of time the person's been around, how likely or soon that the case will be heard, and amongst different factors, and whether there are conditions that he can put in place that can be readily enforced to make sure that this person doesn't reoffend, leave the country, interfere with witnesses, or intimidate any person in part of the process. And then they will make a decision. What they will then do is do what they call a surety. Sometimes persons will have to sign a surety. Sometimes they have to give a cash component. And then there are a number of conditions, including reporting to the police station several times a week, handing in your passport. Curfew, where they have what you call random doorstop checks, where the police can just come up on your door anytime during that curfew period, knock on it, and you knock on your door, and you have to respond within a certain level of time. And of course, the High Court has made it very clear, if you breach any of those conditions, your bail would be revoked and you would have to return to custody.
Understood. Now, in the past, individuals are able to sign bail for someone, meaning, of course, if the individual absconds the person who signed the bail on their behalf, they would be called in and would be responsible for paying the value of the bail to the court. However, recently, there has been a change pertaining to the bail applications, particularly in the magistrate's court for the signing of bail, where persons now have to sign an affidavit and provide property or cash for the bail amount. What exactly caused this change, do you know?
Well, it was never the change. That's always been the case.
Okay.
It's just it's becoming more public what the procedure is. You normally would have to go before the magistrate and swear these documents to make sure that you are a suitable surety in the eyes of the magistrate. Because if that person breaches any of their bail conditions or they abscond, what we would then do is make an application to have the bail estreated, meaning that we would take whatever property would be forfeited to the Crown or the value of whatever you signed for. I think the magistracy and the High Court have undertaken in recent years to make sure persons are more aware of what is required. And I think that's why there's the purported belief of a change. But that's what has always been the case. But it's just that they enforce it now, and they make sure persons are aware of what it means to be a surety. In past, many people would just sign as a surety, not having full appreciation of what that entails.
Understood. Now I want to talk about jury selection. In criminal cases before a jury where the prosecution has somewhat of an infinite level of opportunity to make a potential juror stand down, but then the defense only has 3 opportunities based on my research to object to a juror sitting. How do you feel about this happening, and is that a possibility of a breach of the Constitution?
No, it's not, and I'm going to explain why. Contrary to what many people believe, the reality is standby has not been used since 2015, and that was in a case of a trial ruled by His Lordship Justice Ramdani, where he said, more or less, that the Crown should have equal challenges to the defense. And there have been instances, which the Court of Appeal have ruled have been a breach of constitutional rights, where some Crown have actually made it appear that they've had what I would call use of excessive standby. But that's not normally the case. When persons stand by jurors, people don't understand the history of it. We are a very small community.
Absolutely.
And what happens is the prosecution may know things that the defense may not know, or even the court. Sometimes when you stand by someone, it's not because you don't think they're a good juror. They may be related to the witness. They may be related to the defendant. They may be related to the VC or the virtual complainant. That's VC when I say that term. And you have to make sure it is fair. It is operated, not to give the Crown the upper hand, as many believe, but to make sure it's fair. But now in recent times, the Crown no longer uses standby. We actually use free challenges, just like the defense. If there are more defendants, for example, let's say you have 2 defendants in a matter, and they will have 6. The court will allow us to have 6, just to make sure it's equal. But we will only stand by or ask for a juror to excuse if we know they are related to someone in the matter. For example, I'm a local DPP. There have been many times in my career,
I'm sure,
I've actually had to stand down several jurors because they were all related to me, and it just, they may not be that close to me, and I will not discuss any matter with anyone outside my chambers. However, it looks bad.
Absolutely.
So therefore, you must make sure that justice always has to appear to be done at all times.
I appreciate your honesty in that, because one of the things that I think we fail to understand when it comes to legal matters, like you mentioned, is exactly that we are a small community, and with that, I'm assuming, and you could correct me if I'm wrong, even the jury pool perhaps is quite a minimum. Am I correct?
Yes, the jury pool is minimal. Actually, in Cap 36, which is our current Jury Act, it allows for persons who are resident on all the islands that are inhabited, as well as persons who have lived in the territory for 10 years and over. But of course, that's still a very small demographic when you look at everyone that lives here. Persons who cannot sit on the jury are, of course, members of the House of Assembly and their spouses, persons who have been convicted or certainly serving sentences, members of the police force. Those are persons who cannot be on a jury for obvious reasons. But I think what needs to happen, we need to expand the jury system, or what we need to start doing, especially in the light of the COVID pandemic, is to start doing like other Caribbean territories, which is for certain criminal matters, electing to have a board of judges as opposed to a jury, deliberate on the matter. And of course, that will be something that will be left for both the Crown and the accused person to come to determine if that's what they want. But of course, those are things that will require a constitutional amendment.
Correct. I need to talk about staffing. Do you presently, and staffing at your office that is, do you presently have the full complement of staff at your office? How many attorneys presently work at your DPP's office? And I'd also like to ask you, what would you say you need to effectively, or how many, to carry out the duties of the office?
Okay. Currently, in addition to myself, I have, I'm just counting in my head to make sure I've counted everyone. I have about 10 attorneys. We need more than that. Actually, the current complement of the office is 15 legal staff.
Okay.
We do not have everyone that we need. And of course, there are different demographics that cause into that to getting persons hired. What we do need is that the reality is, when the office was founded, in my view, it wasn't properly set up. We were just the criminal division of the AG's chambers, and then the Constitution came in and bam, we were the DPP's office. And over time, we have added on to our complement to get to where we are now. But ideally, we need at least, I would say, we need at least 20 to 25 counsel to manage the workload that we have.
Wow.
And of course, we would need administrative staff. We have a very small admin complement. We would need at least 15 administrative officers to help us carry out the workload. Because the reality is, the magistrates court carries 90% of all criminal matters. And we have a plethora of matters there. We have matters before the High Court, and we have matters before the Court of Appeal. Because of backlogs due to the coronavirus and of course to the hurricanes, which prevented us from sitting in court until May 2018, because of course we had no court facilities. It's caused a minor backlog. We have done a lot working with the courts to get that backlog eradicated, especially in the magistrates court. And we are working with them to do it, but we need more manpower to be able to successfully do that.
Understood. So presently we're at a deficit when it comes to staff. What plans do you know of? Are there any plans to fill these positions?
Well, I can speak for only my plans. I have written to HR. I am going through recruitment at this moment. We actually have an advert out. I think it closes on the end of the month for senior Crown counsels to apply. And we're working our best to get suitable persons who are not just lawyers, but who are competent in criminal litigation,
Absolutely.
who can actually conduct a high court trial. And of course, as a prosecution office, you need to make sure you have people of good character working with you.
Most importantly, now from my observation on DPP, many BV Islanders study law. For example, let's take the past 10 years or so into perspective. Countless students successfully completing their legal studies. Yet we still notice that persons are still coming in from the Caribbean and other places to fill positions in the DPP's office, which is totally fine. But is there a particular reason local lawyers are not seemingly gravitating to the DPP's office, and not only your office, but the Attorney General's office? Can't some of those positions essentially be filled by locals? What are we looking at? Is it a salary issue? Why is it not seemingly attractive to locals to want to take up these roles?
Well, I can speak to why I believe persons do not prefer to come into prosecution upon completing their law degrees. To do prosecution, it's a difficult job. It's a hard job. Many people do not understand what you're doing or what you're supposed to be doing, and it's what I call a low praise job. Prosecutors get the worst criticism, and we have a high risk job. And the reality is that persons do not wish, as long lawyers, they want to come in, they want to make a good salary, they want to have a good experience. They prefer to go to the private legal sector, in my view, to get probably a better a better salary, and probably work somewhere where there's not a high risk. The reality is, prosecutors are at risk every living day.
Absolutely.
Persons do not understand this. And the thing is, those of us who work as prosecutors, we do it because we love what we do, and we are very keen on making sure that everyone gets justice. We do have local persons who do work within the DPP's office, and as lawyers, as well as admin staff. And one of the initiatives I have started this year, well, last year to be better effective, is that persons who want to study law but have not yet gone to law school, they come in as administrative officers into the office of the DPP. They are trained, they receive training, we help them get into law school,
Wonderful.
and hopefully if they get a government scholarship and hopefully get a government bond as opposed to a territorial bond, then they will come back and work for us. We already have one young counsel who worked as an administrative officer. She's now completed her studies, and now she's a legal cadet awaiting to be confirmed as a Crown Counsel. We feel good we do that. If people get to understand what it takes, they'll be more susceptible to coming in and joining. But the reality is, criminal law is something that a lot of people do not like to do.
Understand.
In addition to that, what we also need to remember, sometimes you need a balance. You can't have everybody from the BVI in the office. For example, what if there's a case where the prominent BVI lander that everybody either knows closely or is related to? You need someone who can independently deal with that matter.
Absolutely.
So that's why we always try to make sure we have a mix of persons. Plus also, I'm of this view, if you want to work for the office and work for the people of the territory, which is essentially what you're doing, I have no problems interviewing you and referring to the JLSC if you meet the basic criteria.
Thank you so much for that. I'm also thankful that you were candid in sharing that the salary is, perhaps there are some disparities in that, because when you look and compare the salary of a lawyer in the private sector to that of one in the public sector, there are huge disparities between the pay. How do you feel about the disparities? Would you say that there needs to be perhaps better considerations for prosecutors and public officers in the DPP's office, or even at the Attorney General, with hopes of perhaps attracting more individuals to the offices?
Well, when it comes to salaries, that is honestly a matter for human resources. I am aware, and I know I have raised it, I know Madam Attorney General has raised it, and has been raised by our predecessors, that there needs to be a salary review in relation to government law officers, to make sure they have the same remuneration and to make sure that we are competitive in the market. Even amongst the other DPP offices within the region, we are amongst the lower end of them. If you compare us to Cayman, Turks, Bermuda, we do not excel as high as them as they do in regards to salary. And at the same time, it also shows, I feel, it will show appreciation for the hard work that it entails. I can't speak for the civil side, and nor will I try to, but as it relates to the DPP's office, it is necessary to make sure that persons are properly remunerated for everything. And it's not just our office as it's for all government law offices and the public service as a whole.
I agree. Now, I want to talk about the role of the media, my role, of course. There have been cases where the media has been prohibited on reporting various matters. What are some of the reasons for this? And can you speak to any of the areas that media should be aware of exactly when covering such matters?
Okay. Well, in 2021, through the Government Information Services, a media policy handbook was sent out to all the media houses, and I hope that they've received it. It helps explain these things. You have to remember, we're about making sure that everyone has justice, and that means a fair trial. If you report certain things and allow blogs on certain matters, you are prejudicing the jury array. Most people do not realize that. You have to be very careful. There's a thin line between the freedom of press and the right of an individual's right to a free trial, a fair trial, a right of a witness for their privacy to be maintained. These are very thin balances that we all have to take into consideration. The right to the free press is not an absolute right. It has to be taken into consideration with those other two rights specifically that I've mentioned. Certain things that we encourage the media not to report on: naming children, children victims and children defendants, putting the photograph of an accuser in the newspaper. Sometimes we don't even want them to put the name of the prosecutor in the paper because you're putting that person in danger. Because you have persons who probably feel that an accused is justified in their action, and they see the prosecutors as attacking their friends and family.
Yes.
They don't see that we're just doing our job for the betterment of the community. Also, pretrial publicity is a real fear. We have had challenges in the Court of Appeal saying that exclusive and continuous, repetitious coverage of a story and blogs could have misled a jury or influenced a jury. Even though his lordship and his or ladyship may tell a jury, please don't go online, the judge is not there over the juror's head when they're at home. And we can't control what they do at home. That's the reality.
So in a case like that, I may ask you, even before a jury is selected, you're saying that this still holds some level of ground?
Yes, it does. Because remember, it goes back to what I was saying prior about us being a small community and having such a limited jury pool. The fact of the matter is, when you have persons who have been convicted and you take a picture of them, I know that the media doesn't mean any harm when they do these things. I understand they want us to know the story.
Yes.
That is their job. However, you have to be mindful that sometimes persons may blog and they may not have the true story or may use it as a defamatory platform. And that leads into the other document that I released in 2020 when the cybercrime amendments were gazetted, which I explained about electronic defamation and the responsibility of the media houses in preventing same. Defamation means that anyone who publishes untruthful and unfounded information that can lower a person's viewpoint of another person, or you just lower the person's character in the eyes of the community, that's defamation. Even though you might not know who said it, the media house is publishing it.
Of course.
And therefore, that is defamation. That's electronic defamation. I at least would implore to the media houses, and I know that we've done it in the past, you can report on the story. We don't mind you reporting what happens in court, but in cases of children, especially sexual offenses, people do not understand this. When someone has been sexually violated, it is the worst crime. It's worse than murder, in my view, because you have to go through that humiliation, that degradation that you were subjected to. Imagine doing that in front of at least 12 people, because remember, you have 9 jurors, Crown attorney, defense attorney, judge, probably clerks, so you're looking at 12 to 15 people. And imagine going home after you give your evidence and seeing that painful recount being rehashed
Yes.
before you in the news, and then all these blogs saying all of these terrible things. Sometimes they're positive. Some blogs are positive in these cases, but a lot of times
They're not.
it's that we have had witnesses who have said they do not want to give evidence because they're scared of what people will say about them in the blogs. And that's discouraging.
I must ask you, in light of that, what measures are in place to essentially protect virtual complaints, victims, as well as witnesses in such a small community?
Well, the protections that we have are for witnesses at the moment, well, virtual complainants. There are provisions in the Evidence Act that allow us, particularly for sexual offenses, to allow that person to give their evidence and in camera. In camera just means it will be the essential persons of the case, meaning the jurors, the judge, counsel, and the accused, because the accused has to be present. Mm-hmm. There are other things that we do for children. For example, we would do their evidence by live video link. So therefore, they will not be in the same room as the accused, and it makes them a little more comfortable. These are things we're doing. We have actually put forward a bill in witness anonymity. That was a bill or initiative initiated by Ms. Kim Hollis, Queen's Counsel in 2018. I have raised it again last year, and I'm raising it again this year, because sometimes we need witnesses who have seen things and they're terrified to come forward because they may receive some form of retaliation.
Of course.
And of course, we also have witness protection program under the Justice Protection legislation of 2011. But that's used in very dire circumstances where we know if that person is released, they could be seriously harmed or killed.
Understood. DPP, I want to thank you so much for taking time out of your busy schedule to come and discuss exclusively these matters with me. We appreciate your time, and we continue to wish you and your office the very best as you execute your duties.
Thank you very much, Mr. Grant.
Viewers, that's all the time we have. Do have a beautiful rest of the day. Ron Grant for 284 Media.